Welcome everybody to today's webinar, which is the second webinar in volume 2 of our scheme sessions series. Now, today we're continuing the theme of pensions risk transfer, and today we'll be looking at the tools that we can deploy to resolve issues that might come on during the buyout journey. So my name is Maddie Frost. I'm a partner in the pensions team at Gowling's. I am a general pensions advisory lawyer, so I'm delighted today to be joined by two of my colleagues who I'm happy to say are very well equipped to lead this session today as pensions disputes resolution specialists. First, we have Charlotte Scholes, a legal director, and we also have Aaron Dunn-Foreman, a principal associate, both here at Gowling's. Now, between them, Charlotte and Aaron have over 20 years of experience resolving issues relating to pension schemes and avoiding disputes. Now, Charlotte and Aaron both sit in our pensions dispute team, which forms part of an 8-strong group of specialist pensions troubleshooters and problem solvers, specialising exclusively in resolving issues that trustees and employers might encounter during the life of a pension scheme. They are not pension advisory lawyers who dabble a bit in disputes, nor are they commercial advisory lawyers who dabble a bit in pensions. They're a specialist group which form part of our Gowling's 40+ pensions team of lawyers who are immersed in pensions and connected to the wider pensions industry. Now, as part of the aim of today's session is to dispel the suggestion that we only reel out the likes of Charlotte and Aaron when things have gone wrong. They are actually people who trustees and employers should want to have a dialogue with. So let me tell you a quick fun fact about each of them. So over the summer, Charlotte was on a flight with Damon Albarn. That's the lead singer from Blur, for those of you who don't know, and unashamedly asked for his autograph, apparently for her daughter. And Aaron is a proud father of 2, although not feeling quite so proud this morning when he was woken up at 2 AM by the sound of both his 5-year-old and his 8-year-old secretly playing in their room. So please forgive Aaron if he's a little bit tired today, but I'm sure his energy and upbeat nature will see him through. So just before I hand you over to our experts, just a couple of housekeeping points, if I may. The session is due to run until 1 PM. We're going to aim for no more than 45 minutes of content to give plenty of time for questions. And if you do have questions as we go through, please do feel free to use the Q&A function at the bottom of your screen. Now, only as speakers will be able to see your questions, so ask away. There's no stupid questions here. We'll pick up as many of those as we can at the end of the session. And just so you know, we will be recording the session. We'll place it on our website following the session, and we'll send everyone who signed up a link so they can watch the recording at your leisure. So that said, over to Charlotte. Thanks, Charlotte.
Thanks very much, Maddie, for that excellent introduction. Good afternoon, everybody, or good afternoon by 4 minutes. Welcome to today's session. As Maddie said, the theme for this is risk transfer. And what I wanted to start off with is just reminding everyone that obviously when a scheme reaches a funding level that buyout becomes within reach, that's obviously a really good place to be. However, as anyone who's ever been involved in buying out a pension scheme will know, the journey to buyout can be an interesting one. While you may start out with expectations of it being a bit like walking through fields of lavender, you may find that things aren't quite as they first seemed. For starters, the lavender, as it turns out, is in fact bluebells. Yes, that's what's on the slide. Or worse still, the journey to buyout can be somewhat full of potholes and challenges. And the purpose of today's session is to show you that notwithstanding those challenges, there are ways that your legal team, and in particular disputes lawyers, can help you. Any solution needs to match your project plan, and we understand the buyout industry and the standards that insurers expect. But before we leap into what those solutions might look like, I'm going to hand you over to Aaron to ask you some interesting, fast questions. We want to get a feel for the sorts of problems you may have faced in practice and what attitude towards engaging with dispute lawyers you have. Over to Aaron.
Thanks very much, Charlotte. So as Charlotte mentioned, what we wanted to do was get a feel from the audience as to the kind of problems that you are all experiencing and see if that's aligning with what we've been seeing. And hopefully we'll be able to flex our session around the responses you're able to give. So if I am clever enough to work the technology, which is not guaranteed, the first question I'd like to ask you, and it should come up as a poll shortly, is actually, of the people on here, how many of you, or have you ever come across problems with your pension scheme? So hopefully that has come up for you, and we've got three options for you. You might be sitting there and thinking, oh yes, my pension scheme runs like a dream. You might be thinking, oh, I only have problems once or twice. Or you might be thinking, I have problems all too often. So I'll leave that poll open for a moment longer to let others finish their voting. I can give you a quick preview now whilst those votes are still coming in. Not a huge amount of you are saying your schemes all run like a dream right now, which difficult for you, but at least you're in the right place because that's what this session is all about. So I will publish the results. And again, hopefully that's coming up on your screen so we can see where we are. And, you know, it looks like 88% of you have experienced problems at least once or twice, if not all too often. So, okay, you're in the right place. Now then, our next question is really trying to flash out, well, what are those problems that you're coming across? We'd like to know what's the most common problem out there. And again, we can flex our session around that. So if I've worked the technology correctly again, you should see up on your screen the options. So is your most common problem error in your scheme's rules? Is it missing documents? Is it simply members are not being paid correctly? Or are you having more disputes with your service providers than perhaps you once did before? Feel like I've got quite a lot of power here because all the results are coming in for me and I can see them. I don't know if you can all see them on your screen as well. I'm told you can, so I don't have as much power as I thought. What you can see then, and I will end the poll now. One more, 2 votes coming in. So if I put the results up, just in case others couldn't see them, we've got a real mixed bag there. But what's coming across is actually the problems you're all dealing with cover all of those topics. And it's interesting to see a few people are having increased disputes with their service providers, because I think if we'd ran this poll a couple of years ago, that wouldn't have featured quite the same way. Okay. Now then, my final question, and this is a slightly high-risk question that Charlotte and I are going to go with, but we're going to go with it and see, is what is your first reaction when you're told you have to involve a pensions disputes specialist? Now, you might think, great, who doesn't like working with a friendly pensions dispute specialist? You might think, oh no, that's our journey plan gone up in smoke. They're not going to understand what we're trying to achieve. This is just going to get legs of its own. Or you might think, oh no, this is going to be far too expensive. Selfishly, I'm going to keep the poll open slightly longer because I've not had many great, this is who doesn't like working with a friendly dispute specialist. So I'll give you all a bit more time to see if that changes. Oh, it is. It's picking up. I feel like I've influenced the results. I'll just leave it open one more minute or so, one more moment or so. Okay, I'll close the poll there and I'll share the results with everyone. And I am pleasantly surprised that at least 20% of you are okay and like happy to work with your friendly disputes team. That's great. But, you know, not surprised at all here that there is this combined perception of, if you parachute in some pension specialists, we're not going to know what's happening with your journey plan and it could compromise it. Things might sort of get their own legs. And also a huge number of you worried about what the costs are of sorting these problems out. So without further ado, you're in the right place for all of those things. We'll try and pick up on some of those concerns as we go. And let me just tell you where we're going next. Hopefully my slide has moved across. Fantastic. What we're going to cover today then is we're going to talk to you about the common problems that are coming up. And we've seen some of that in the survey results there. we're going to talk to you about what we think the aims should be when a problem comes up and how we would like to engage with you to understand what your aims are and how we need to solve these problems. And then we'll go through the all-important fixes. What are the tools in our toolkit to help resolve those problems? And then Charlotte and I always think it's really important on these webinars or conferences to actually then back up what's being said with some case studies to show how it works in real life. And we think those case studies are really quite interesting and in some ways the best part of this. So we want to make sure we've left enough time to go through a couple of case studies for you. So without any more, I'll pass back to Charlotte to talk about problems.
Thanks, Aaron. So what sort of document problems might you see in practice? What sort of problems might emerge? These may be familiar to you already, but I will, for the reasons Aaron's explained, rattle through some of these. So first up on the list of potential issues is execution issues. So the most common example is where you find there's a signature missing in a deed. That's obviously less than ideal, but can be quite common. Second on the list are drafting errors. So an example of this would be where the deed and rules confer a higher than intended level of benefit on members, and this doesn't reflect the intention of the parties at the time. Commonly, one might see this in the pension increase rule. There have been quite a few drafting errors we've come across recently in those sorts of rules. Another very common area for document problems to arise is around changes to reflect the Barber decision, so sex equalisation changes. Often there's been a defect in the process for seeking to implement those changes. The very common mistake is where an announcement's been issued where a deed should have been done. That is quite a tricky problem to resolve. However, there are lots of variations on this general theme, and we'll come on to talk about some of those later on in the case studies. And there are potential ways to get around those. Third up on the list, even fourth on the list, is closure issues. So these typically occur where there's a courage restriction in the amendment power. Now, for those of you who aren't massively familiar with what a courage restriction is, essentially a courage restriction, or a courage fetter as it's often known, is a restriction in the scheme's power of amendment which prevents the trustees and employer from severing the link with the final salary of members at the point where the parties want to cease accrual of the scheme. Now, courage restrictions are usually unearthed at the point the scheme tries to close to future accrual, but very occasionally the issue emerges many years later when a scheme's going through the DD process and preparing for buyout. So the question then is, what, if anything, can be done to remedy the position after the event? And the final item on the list is missing documents. Now, often we know a change has been made, but we can't find evidence of the relevant decision-making. And I think it's fair to say it's the way of the world with pensions, that they often have a very long lifespan, and often the documents and the changes go back a number of years. So often documents do go missing. Very often they go back to the age of paper or even parchment. And certainly they predate the age of emails and cloud storage. So those are the document problems. As Aaron's mentioned, there are also various practical problems that can emerge. So I'm just going to let Aaron speak to you quickly about those.
Thanks very much, Charlotte. So what Charlotte's sort of taken you through there are documentation problems where at the core, the benefits that you might have been paying to your members might actually not be the correct benefits in accordance with the trust deed and rules as a result of those various documentation problems. So they're very much your legal problems with your documentation. But of course, that then links in with some practical problems. So just to keep us on our toes, I'll take these in reverse order as they appear on the slide. Of course, if your benefits are not as you thought they were because you've got documentation problems, that will almost inevitably mean you have some administration and data errors, and members have not been paid correctly historically, which has two consequences. One, you'll need to fix their benefits going forward, and before you can sort of conclude your buyout journey and consider what policies you need to be putting in place. But you might also need to look back and see what has been gone wrong in the past and whether you need to correct past errors, underpayments, overpayments, And that is a very common practical problem that schemes will have to grapple with as they start to flush out issues in their buyout journey. The other practical problem that we're seeing more often now is difficulties with your service providers and perhaps exiting difficult contracts. So what we have in mind here are problems where, because the market is quite buoyant at the moment, maybe your service providers don't have the bandwidth that you would expect them to have to help you complete your projects as part of the buyout journey. Maybe increasing errors are creeping in and you're finding it very difficult to manage what the project is with those service providers. And you're just basically having frustrations with those who you've worked with before and trying to find ways to either exit those contracts as the last resort, but more generally trying to find ways to fix that relationship and get things back onto an even keel so you're all sort of pulling into the right direction for your project. So they're some of the practical problems that we're coming up across, and hopefully that resonates with some of you, and these are sort of things you're also seeing. And if there's other things that you're struggling with or problems you're seeing that we've not mentioned, do pop something in the Q&A and we'll try and get to that as well. So I'll hand over to Charlotte now. So we've told you what the problems we're seeing are, and now for the all-important piece around what are our aims? What do we do when we discover a problem?
So thanks, Aaron. One of the first things that we do when one of these problems emerges is we ask ourselves what's going to sound like a very basic question, but it's actually a very important question, which is this actually really a problem? Now, I just say, just because someone else has said it's a problem, we don't necessarily assume it will be. At the risk of saying something that you may already be familiar with, if you ask a room of 10 lawyers the same question, you may get 10 different answers. So it is important to consider whether what one person has said is a problem is necessarily going to be construed as a problem by someone else. Often it's worth reading around the troublesome clause in question and seeing if other clauses may come to your rescue. Another really important question to ask is, what's this problem worth? Now, although we've included this in as a second question on the slide, in my book, this is actually always the first question to ask. Clearly, there's no point trying to fix a problem that's only worth a few £100 or, frankly, a few thousand. But if you're talking about a drafting error that gives rise to unintended liabilities worth millions of pounds, that's obviously going to dictate the approach you are going to want to take. Once we've established the answers to those questions, we will then think about some of the fixes. Now, at the risk of sounding like Bob the Builder, we do ask, can we fix it? And most of the time, the resounding answer is yes, we can. But every now and again, it's not possible to fix a problem. But the point of today's session is to focus on what we can do. So just moving over to the next slide, one of the key aims and part of forming our strategy is to work out how we keep stakeholders on side. So how do we do this, you might be wondering? Well, what we work out really early on, where's the scheme at in the buyout process? Is it right at the start of the process, for example? Is it 6 months in, or does it have 6 months to go? That's obviously all going to dictate the steps that we take and the strategy we form. And if the scheme is on the cusp of signing a deal with an insurer, our approach is obviously going to be radically different to a situation where buyout is 5 years off. Ideally, problems are spotted with time in hand. And if that's the case, we will try to work with stakeholders to ensure that the scheme isn't out of pocket insofar as we can. So, for example, if there's a potentially responsible party, we'd help the trustees and employers to recover, whether that's by way of a professional negligence claim or simply via having a commercial negotiation, leveraging a pre-existing commercial relationship. We would have that conversation with trustees and employers and the relevant party to try and find some kind of recompense for the scheme and make the scheme good. So that's the theory, but how does it work in practice? You know, what tools do we have available to us to help, and what might those solutions look like? So at this point, I'm going to hand over to Aaron to talk about some of the fixes.
Thanks, Charlotte. And at the risk of stretching your Bob the Builder analogy, I'm not sure if we're allowed to say that for trademark, but I've said it now. We're going to really looking at the tools in our toolkit here. So we've kind of tried to put these in an order of the easiest tool to use first, the easiest, cheapest, quickest tool to use first, and then sort of moving down that process. So looking first at fixes for your documentation problems is, as Charlotte flagged, one of the key tools we have is actually, can we read the rules another way? Do we think this is a problem? Or can we find other parts of the rules that might save us? So even if on the face of a particular part of the rules, it looks like there's a problem, if we take a step back from that provision and look more widely, can we find support from other rules that either minimize the impact of that problem so you can live with it, or eliminate the problem altogether? So that's our first objective. If you're coming to the Gowling Pensions Disputes team, that's what we're looking at doing first, because that's the path of least resistance. If that's not possible on its own, we kind of look outside of the rules, because occasionally you can find support or information or evidence of what was intended and what was going on outside of the rules. And that can also help us formulate a strategy with you around to how to resolve this problem in the time frame that you have, and giving sort of due credit for all the liabilities that are at stake. You know, they're all of the importance of this matter, your timetable to buy out, all feed into the strategies that we work with you to develop. And often evidence gathering is quite key. And we might look through documents, we might want to speak to key individuals. And really what we're trying to get to here is if we can't find a bulletproof way through those rules on our own, what trustees will need for comfort, what the employer might want for comfort, but really importantly, what your insurers who are taking on liabilities will want for comfort, is an opinion from a barrister, and specifically from a KC. And so that's the next step of our problem-solving toolkit, is actually working in a collaborative way to put together a case that would enable a barrister to sign off on a position that is an acceptable outcome for all parties. And you won't always get the right answer from the barrister immediately, but that's why it's very important for us to engage with the barrister in an iterative process, so that we can say, well, this is what we have looked at, this is what we haven't looked at. If we're not at the point where you can sign off and give some comfort around this, what more could we look for? What more do you need? And we will try our best to find a solution to most problems that we can through this process. Because, as I said, our goal is the path of least resistance, the most cost-effective and fast solution. So that's why it's really important to evidence gather and work with your barrister in that sort of collaborative way. Coming very quickly on to practical problems as well. So that whole process, those fixes work for your documentation problems. But I also spoke to you about your practical problems. I gave you an example of some frustrations with your service providers, perhaps not performing the way you'd want them to perform, and perhaps not having the bandwidth to help with your projects, be that GMP equalization, reconciling your data, doing any of those various steps towards buyout might be sort of feel like you're hitting your head against a wall at times. And ultimately, one nuclear option would be to replace them and terminate the appointment. But we all know in reality, depending where you are on your journey, that is not a very practical solution. And in fact, gives rise to its own problems. So what are the fixes for these practical problems are, well, you can look through the contract and we can help you find some contractual levers that you can pull to help focus minds and to help get your service providers back on track with you. But in addition to those, you've got these commercial levers that you can also pull to get their focus, get your attention again. Things about, they'll have concerns about their own reputational issues, and engaging with them in a dialogue can often solve most of the problems, because ultimately you all want to work together to get to an outcome. And I think in that part of that piece there as well is, you might find sometimes that the compounding problems with, for example, the way your benefits are being administered might to start give you concerns that there is a breach of law that needs to be reported to TPR. Now, of course, we as legal advisors would not race to reach that conclusion to say that you need to report a breach. But if you start to move into that territory, you're opening a dialogue with your service providers along the lines of, we're concerned if this doesn't get sorted out soon, we might have to report it to TPR, can sometimes be a really effective way of getting attention from the more senior people at those organizations to get them back on track with you. The other two bullet points in the middle there, I'll just touch on very quickly. This is, how do you fix practical problems where the scheme is out of pocket? Well, you know, sometimes innovation is really an exciting word right now, but what these two other bullet points in the middle here, early correspondence and the pre-action protocol, that's really just focusing on writing to people and trying to get a deal done so you can move on. You know, problems happened, it's cost X amount of money, let's make good that money and move on with our project, please. And I think all too often people overlook these two steps here and think straight away about costly court proceedings that are going to take time. And we've got a couple of case studies, I think, which will help bring out that sometimes cracking on with a quick commercial settlement is very effective and often overlooked, and people think it's better just to ignore it because we don't want to get caught up in litigation. The final kind of fix for practical problems, I mentioned overpayments and underpayments there and taking a practical approach to that. And I think that could be a whole session on its own. So I'll just sort of distill it down to this, which is you need to look at that as a project in and of itself and involve your advisors in that as soon as you can. Because yes, whilst technically speaking, the legal position is that you should seek to recover, for example, past overpayments and correct benefits going forward. If you've overpaid 100 members £1,000, which is a significant amount of money in total, the practical reality is writing out to those 100 members, triggering potentially 100 disputes to try and wrestle £1,000 back off of each of them might cost you a lot more money and time than it's worth in the context of what you're trying to achieve with the scheme in your particular journey plan. So it's about looking at those problems practically and finding a solution which actually brings your members along with you and minimizes the scope for costly complaints and delays. Okay, so we've kind of, Charlotte, I kept forgetting, what did you refer to this in our when we were talking about this wheel of fortune? Is it?
It looks a bit like the wheel of fortune.
Okay, so what we've done here is we've put together a wheel of fortune, which just tries to pull together in one slide for you what these fixes might look like. So the outer edge, if you like, are the more practical fixes, and the inner core are the more involved legal processes. I will very quickly pick off a couple of the ones from the outer core of the Wheel of Fortune. And I've touched upon some of them already. So I mentioned that we might have an iterative process of seeking a counsel's opinion to help solve the problem. And part of that iterative process would involve checking advisor files, interviewing key people from around the time, and basically amassing as much evidence as we can to put before counsel and find a solution. That will involve checking members' records as well. And the final one that's worth pulling out here, because I think it is so often overlooked because it seems like you'll never get it, is member consent. So when you've got issues with your documentation, the biggest problem is you can't retrospectively change benefits if that's going to be detrimental to members. And so, yes, with your big, large-scale errors, member consent might feel very impractical and frankly impossible. But if you're dealing with a specialist subset of your membership, a special category, or an unusual category of members that's come in from the history of the scheme, they might represent a high liability, but not a huge number of people. And actually trying to at least consider a member consent strategy is well worth it. So having picked off the easy ones to talk about, I will now hand over to Charlotte, and I've left her the more technical inner core just to run you through.
Thanks, Aaron. Totally agree. Member consent so often overlooked. It's a really good one to bear in mind. So as Aaron said, I'm going to talk now about the inner core, at the risk of mixing analogies between the earth and the earth's core. I'm going to just leap straight in. So construction is the first one. I'm going to move around clockwise. What is construction? Well, we're not talking about building here, despite all the references to Bob the Builder. The point about construction is occasionally documents just don't make sense. And where that happens, parties can ask the court to construe a document for them. So when we talk about construction applications, we're referring to the process by which the court determines the meaning and the legal effect of a document. Now, it's worth saying that such applications are only suitable where there's no underlying factual dispute between the parties about the nature of the document or how it came into being. And the only matter in dispute is effectively the correct interpretation of that document. What happens is the court considers the document and decides the correct interpretation. The evidence in such cases is very limited. The court's basically looking at the document and construing it on its face. So, for example, the background documents, the admissible evidence is pretty limited, and previous negotiations between the parties and their declarations of intent. So, for example, the emails around the time generally won't be admissible. What the court will try and do is they'll try and take a sort of practical and purposive approach, and they'll try and apply business and commercial sense to a document. Usually this is a friendly and consensual route where all the parties work together. And generally what you'll have is you'll have an employer arguing for one interpretation, which tends to be the cheapest option. And then the trustee may argue on behalf of members for the more generous interpretation. However, sometimes the trustee will just stay neutral, and you'll have a representative beneficiary who will take on the role of arguing on behalf of members for whatever confers the greater benefit on members. Now, you might be wondering, how long do these sorts of applications take? Well, they do vary. At the one end of the spectrum, you can get cases on within a couple of months of getting the papers to court. And you can even have them dealt with without a court hearing. In other cases, it can take a bit longer. For example, if there's a bit of tussling between the parties, they're often front-end loaded processes. So it could take, a year, maybe 18 months. But as I say, you can get these cases on within months. What's the legal effect of getting a ruling from the court on construction? Well, it binds members, which is good. And the trustees are bound to follow the order. So from the trustees and the employer's perspective, that is a pretty good outcome. And there's not much members can do to dispute the court's order. So next up on the Wheel of Fortune is Section 48 of the Administration of Justice Act 1985. Now, I'm taking this next because it's staying on the theme of construing documents. It's actually quite a handy procedure, and it's not used that often and not really publicised that much. So what it does is Section 48 of the Administration of Justice Act allows the court to authorise trustees to take action on the basis of counsel's opinion. In other words, if the trustees or the employer are able to present an opinion to the court to say they think the document should be construed in a particular way, or rather counsel opines that the document should be construed in a particular way, and the judge agrees with that, you effectively have a blessing from the court, blessing the trustees' actions for administering the trust in accordance with that construction of the document. So, for example, the court could bless a trustee to construe a rule in a particular way, to construe away any plainly erroneous wording. Now, this is a pretty simplified process. Although such hearings, if they do take place as hearings, they can be dealt with on paper. They tend to be pretty short. You can even have telephone hearings, and the costs of seeking such an outcome from the court tends to be lower than would be the case for a construction application. So what you might be wondering is what's the real difference between going for a construction application and an application under Section 48 of the Administration of Justice Act? Well, the crucial difference is the court's decision isn't binding on members. Although the trustees would be protected from the maladministration claims, technically members can still argue that the interpretation adopted by counsel and the court is incorrect. Now, I think that's going to be quite a difficult thing for members to do. So in practice, the risk probably is pretty low, but it's just worth being aware of that distinction. Next up on the Wheel of Fortune is rectification. So why would you use rectification when you've got construction Section 48 available to you? Well, the answer is this. If there is clearly a mistake in a document, but perhaps the mistake isn't necessarily apparent on the face of the document, you might be looking at rectification rather than construction. So what is rectification? Just very, very briefly, because I'm conscious we need to get onto the case studies. It's an equitable remedy, which basically means that it's only available at the court's discretion. It can be used to rewrite mistaken wording in a legal document so that it accords with what the parties to the document had intended. Parties can't agree to rectification as between themselves. Now, it's worth flagging that because sometimes deeds of rectification or deeds of correction emerge during the risk transfer DD process. And those deeds, unless they're backed up by a court order, don't have any legal effect. Now, that's not to say they're entirely unhelpful, because of course what they do is they evidence the intention of the parties at the time they're executed, but it is worth being aware of the fact that they don't of themselves have any legal effect. Rectification tends to be sought by employers who are obviously looking to put right any provision in a pension scheme that's likely to cost them more money. If such applications are granted by the court, they are binding on members and all the parties to the application. Well, they bind all the members of the trust. As is the case with construction applications, you tend to have a representative beneficiary involved, but occasionally you just have two parties. You might have the employer arguing for the cheaper option and the trustee arguing on behalf of members. Every now and again, it's so clear that there's been a mistake that the parties to a rectification application agree that it can be dealt with on what we call a summary basis. And that means that effectively the party whose role it is to dispute the rectification says, I have no reasonable prospect of arguing against the fact this was a mistake, so I'm not going to have that argument. In which case they may get an opinion from counsel that they share with the court on a confidential basis, and the hearing could be dealt with in a very short period of time, potentially a day to half a day, and potentially for a fraction of the cost of a full-blown contested rectification case. So that is a real whistle-stop tour of construction, Section 48 and rectification in the inner core. We're now going to move on to the case studies, which I suspect are going to be the most interesting bit for all of you guys. So without further ado, Aaron, please move the slide on. Thank you.
Thanks very much, Charlotte. So what we will try to do here is bring to life with some case studies that are based on some previous experience to show how sometimes practical solutions and looking at ways to resolve issues and avoid disputes can actually get you the best outcome. And it's not always the fears you had at the start of this webinar around what it means to involve pensions dispute specialists. So I'll kick off with our first case study. And this is an interesting one insofar as it is a problem that is not unusual. This has come up on many schemes where it looks like pension increases and revaluation has been applied incorrectly. And it is a problem that has a big monetary number against it when you come to buyouts and when you detect the problem and what to solve. And it's also a problem that can cause quite a lot of emotion between members, trustees, and the employer. Members who want the better benefits, trustees who feel they need to stand by how they've administered the scheme, and the employer that needs to fund it. So I think the main thing I wanted to bring out of this case study is to say, when this problem arises, that you're looking at something has gone wrong over a very long time horizon, and there are two implications for that. That is, more money might have been spent in the past paying out higher levels of benefits than were due, and more money might be spent in the future securing a higher level of benefits as part of your end game. If you are looking to find a solution to this problem and to avoid a dispute, you can work collaboratively with all the parties involved to test what might be acceptable to everyone. And when you're in the context of a buyout and looking at the end game, what is acceptable to parties might be quite different to what was acceptable to them when they're not near that process. So to give you an example in this case, what was decided upon and a documentation was put in place to make this very secure on all fronts was that whilst it seems members had been overpaid for the past, and those members could have had back payment, been required to repay previous overpayments, the employer would agree to an augmentation for what had been done in the past to make that good. And that was on the basis that all parties agreed that for the future, and in terms of looking at what a buyout might look like, the benefits would be corrected for the future. And so what that meant was that trustees felt that they had secured a good outcome for their members. The employer kind of weighed up the cost of agreeing to waive what had happened in the past versus the cost of the exercise of trying to get any of that money back and the cost to the relationships and the delay that might put on the project, and was comfortable with augmenting benefits for the past. And it also meant that the trustees could write out to the members and explain what had happened and bring the membership along. And in the end, you have very few complaints, and it is an equitable outcome for everyone. So that was an example of a very big problem that could have cost a lot of money. And if it had gone to court and been litigated over or had hundreds of member complaints, it would have been significant. But kind of working in a more collaborative way and finding more practical solutions that respect the buyout journey, you can find a solution that avoids a dispute arising. So that's case study one, which I thought was worth sharing with you. Charlotte, I'll pass back to you and see which one you're picking up next.
Right, so I was going to speak a little bit about problems with sex equalisation. So this is where the validity of an amendment to equalise NRD is called into question. So this is basically a hypothetical case study. But imagine a situation where the trustees of a scheme are advised that there are doubts as to whether NRD has been equalised when intended. This may sound very familiar. And in this particular example, as was common in the 1990s, you have the same individuals who are both company directors and scheme trustees. But the issue here is that the amendment power required evidence of consent to the amendment by both the trustees and the employer in those separate capacities. But there is a lack of contemporaneous evidence to show that both parties, so the trustees as opposed to the directors, have in fact positively consented. Or just to put it another way, you have evidence showing that an individual's given consent in one capacity, but you don't have evidence showing that that individual's given consent in another capacity. So in essence, the issue is a lack of evidence. So you might be thinking, what can you do about that to plug the gap in the evidence? And I say, well, the example in this situation is after you revisit the company archives or the trustee archives and the minute books, it is reasonably likely that you will find some more documents. And indeed, in one particular example, we did. I'd also suggest you contact all the key individuals involved in the amendment to the extent that they're still alive, and seek to obtain witness evidence from them. So, for example, you might include the company director, the company secretary, and former directors of the company. Some of them may have retired. I appreciate some of them may not all be around, and also look to speak to the former trustees. Then, next up on the strategy list is to approach leading counsel with this evidence. And indeed, in one case, this is what we did. We collated all the evidence we could and go to leading counsel and ask him to opine on the basis of the evidence collated to date. However, in our particular example, counsel gives an initial opinion that, while he's got a lot of sympathy and he can see there's been a decision to change NRD, ultimately he suggests that some further digging is done. So what this demonstrates, and this is a point Aaron's made at the outset, is this is an iterative and collaborative process. So in our example, you go back to counsel a number of times with updated evidence and further documents. And you go back to the parties I've mentioned already, the company secretary and the former directors of the company. But what you find is that you swiftly produce a bank of evidence that satisfies counsel. And in the end, you get an opinion from counsel that upholds the validity of the change to NRD. Now, this may all sound like a fanciful situation, but it is actually based on a real life story. So we know it works in practice. And what this does is it doesn't just give the trustees the certainty on how to administer the scheme going forward, and also obviously helps with the past, and it protects them from any future criticism that the change hasn't been validly made, but it also saves them millions of pounds in unintended liabilities, avoids the cost of court proceedings, and it has the further benefit that when the scheme actually gets to the buyout point, which could be in months or could be in years, it has an opinion from a KC that it's able to show to an insurer to persuade the insurer that there are no issues with NRD and that the scheme's been properly equalised. So that is one example. Aaron, I think you were going to take the next example, talking about drafting errors and what you might do there.
Yes, and I'm also conscious of time. So do you think we should look to do one more case study and then look at the questions, Charlotte?
Absolutely, no problem. And I can see that there are some questions that come through in the Q&A. So totally agree with that.
I was going to fire one at you as part of your case study, but I thought that was a bit unfair, and perhaps we'll pick them up at the end.
Very kind, thank you.
So the final case study, and I'll do this one quite quickly, and I think it's worth picking this one up because case study 1 and case study 2 kind of showcase using clever legal mechanisms and working in quite a clever way to resolve a problem. And case study 3 resolves your problem, but it's not this big, clever, innovative thing. It's just a good old-fashioned getting a deal done. And so the case study here is a drafting error was detected of the type that Charlotte described, where something had gone wrong with the drafting, something had been cut and copied from one previous version of the rules and dropped back in a slightly different way. And the result of this was it created a much more generous benefit for a category of members. Now, fortunately, that was quite a specific category of members. And so when we did the other thing Charlotte flagged, what's it all worth? The liabilities kind of fluctuated between 800,000 to £1 million. Not a small problem, but not an insurmountable problem. And we quickly looked at the rules to see if we could read it another way, but there wasn't a safe way to do that. We thought there would have been a strong case to go to court and have it rectified, but that would cost more money and take more time than it might be worth. And so instead, we went straight to engaging with the providers that had done the drafting wrong in the first place and trying to get a deal done. We're going to have to insure that benefit because it's cheaper than trying to fix it, but let's make sure we're not out of pocket doing it. And I think it's a good case study to flag because from start to finish, that process took under 12 months. And as a result, an agreement was reached where about 80% of what the additional liabilities cost was paid into the scheme. And it's just that kind of problem where if you don't know about these practical fixes, that you might just think, do you know what, let's not even look into this because the legal costs and the time it's going to take to try and fix this, it will all come out in the wash in the buyout. And that might be true. And it does depend where you are on your buyout journey, but there are these fixes out there. So I think we'll leave the case studies now and maybe pass back over to Maddie to chair our Q&A.
Maddie, I'm very happy to take one of the questions that's coming about private investigators, because I do actually have experience of this.
Okay, Charlotte, do you want to, should we kick off with that one then? As you mentioned, we do have a question come in about how far can you go to find people from the time? Private investigator, double question. I like this one.
So I assume that this question, the person perhaps who's asked the question may wish to elaborate further, but I assume this question is being asked in the context of perhaps recovering overpayments, because this has been my experience of where it's come up. So sometimes one of the situations in which you find yourself is overpayments are made to members after death, and they can go into their bank account and they can be mysteriously spent. And it can be quite a business trying to track down the potential party from whom you might recover that money. And often you find that despite your best attempts to send lots of letters to the executors of the estate or those that are responsible for dealing with probate, you're not getting any responses. And it has been in that context that I've used private investigators to effectively go and find where that person lives. And you can also get asset reports on the extent to which recovering overpayments from that individual is going to be a worthwhile exercise, because clearly there's no point pursuing somebody who doesn't have the financial wherewithal to pay you back. So I have used private investigators. I don't know if it's in the context, if you're asking also in the context of looking for missing beneficiaries. Haven't used them in that context, but I don't really see why you couldn't.
And Charlotte, as I know that you probably won't be able to see the Q&A at the same time, the person that's asked that question has also sort of clarified to say, I think it's all in the context of when you're doing your investigation.
Oh, right.
I think a deed has been executed incorrectly. So in your case study that you gave around going to individuals at the time, it's how far do you go to trace down those people to try and help build your case?
Oh, okay, right. I've seen that elaboration now too. Well, I suppose this goes to the whole cost benefit analysis, doesn't it? If it's going to be worth absolute millions of pounds, then I think it is worth using a private investigator. We'd normally go down the usual routes of Companies House, and then there are various other resources we can use to try and track down people, where you can basically do desktop searches. But yes, if I thought the problem was worth millions of pounds and we wanted to track down a former trustee and we knew they were out there, I would use a private investigator.
Thanks, Charlotte. I'm just clicking through the questions to try and find the most tricky ones for Aaron. But what I'm getting, I would quite like the answer to, Aaron, and that is, what do we do if we go through the process you mentioned, we get a case's opinion, but we just don't like it?
Oh, the question of, I don't like that opinion, can we go to speak to another barrister and get a different answer, please? Yeah, that's really tricky, even more tricky for trustees who don't get the same luxury of opinion shopping, really. But I think the key thing here is it's about taking control of that process of instructing counsel. Counsel, we need to work in an iterative way with them, and we need to set out the instructions in such a way that counsel doesn't inadvertently shut the door on something when he's not been asked to do, or where she's not been asked to do that. And I think I would compare it to those of you who work closely with your legal advisors might ask us a question, and sometimes you'll get an email saying, I think we'll have a quick call on this, and we will discuss some issues with you before sort of finalizing advice and kind of reaching a landing. And it's just about managing that same process with counsel. So if you get an opinion from counsel that you do not like, the trick of it is making sure you've structured your instructions and structured the way you're going to counsel in such a way that they shouldn't ever give you a definitive no. It's well, this doesn't work for this reason, this is what you need to do next. And ultimately, if you go through that process and you still don't like the opinion you've got, that probably means you've just got a very difficult problem, and your quick fix of going to counsel isn't going to cut it, unfortunately.
Okay, let's get to another question. One of the things I often find with trustees when something disputes come along is this idea of communicating with people and this concept of privilege, and it's often something that's quite difficult to grapple. Charlotte, you mentioned this. I wonder if you can give us a little bit more about privilege and what that means and what trustees should be aware of.
Yes, absolutely. And actually, I should say that because we pulled up slightly short on the presentation on the slides, this was actually going to be one of the key messages I was going to give to people, which is, if you do discover problems in your pension scheme documentation, it's usually a good idea early on to get the lawyers in as quickly as possible to ensure that you cloak those communications in privilege, and that you don't produce a very large evidence trail saying, gosh, we think we've got this terrible problem in our scheme rules and it's going to cost us this amount of money. Because if that all happens without it being for the purpose of seeking legal advice and an attorney-client communication, then there's a risk that that's disclosable to members in due course. So the point around privilege is just making sure you involve lawyers early on to make sure that those communications don't become disclosable to members. Well, and frankly, unless and until you find a communication, you might want to keep the existence of the problem under wraps. And then once you've found your solution, to the extent that members need to be told, you can, reveal the nature of the problem to them. Does that answer your question, Manny?
It's not mine, but yeah.
I think I would add to that, because I think I might have dropped that last slide off, but it's actually a really important point that Charlotte had there, was that the key thing there is don't panic when you have these problems. And in the same way I mentioned that we would pick up the phone to you if we need to talk through something, if this thing comes up, the easiest thing to do is an email that says, we trustees need to jump on a call, please. We can talk about it then, what the problem is. So, in that first initial flush of looks like a problem has come up, I know not all of us are so good at picking up the phone anymore, but trying to manage that process at first by having some phone calls and then working out how you're going to deal with it is quite key.
Okay, probably just a final question. Aaron or Charlotte, Aaron, you might want to. And I have some sympathy with this question, actually, being involved in risk transfer work for trust. It's quite intense, that period leading up to buy-in, and then there's still lots of things to do before buyout. We discovered, like trustees, employers discover issues like this. How on earth are we going to manage that and manage the buyout process? Yeah,
it is a really good question, and you'll see here that I'm waiting for Charlotte to say if she wants to pick it up or not. But I'll take part of it and see.
Maddie didn't assign it to anyone, so I assume it's you, Aaron.
So I think really what is key is you need the people that are coming in to help you solve these problems to understand your scheme, understand the market, and understand where you are on that journey. So there's no point parachuting in a litigator that doesn't know what's happening with your scheme and what your objectives are, because they're not going to be naturally finding solutions that work with what's happening there. So Charlotte mentioned a few times, the solution that we would be looking for you will depend on where you are on your buyout journey. You know, if you are 2 years off and the problem is multi-million pounds, you might want to start putting in a strategy that will fix that multi-million pound problem so it doesn't jeopardize your timetable for buyout. On the flip side, if you are on the cusp of completing on a buyout and you have discovered a problem, one of the first things you might want to do is actually engage with the insurers and see what they would price to give the better benefit. Because actually, if there is money there, or if there is an employer standing behind that's keen to drive the buyout through, that might be the most practical option. So insofar as I've understood the question as how on earth do we fix these problems without messing with the buyout timetable or what all the other projects we're doing, the answer to it is the solution should be shaped around that.
Maddie, I've seen other questions come in actually, which I'm very happy to take if we've got time.
Yeah, I think Charlotte, we've probably got another minute or two. So if you're happy to take the question that's just come in, I think it's a really good one. And the question is it better if you're seeking counsel opinion regarding a dispute over the interpretation of the rules? Should trustees do that independently of the sponsoring employer or collaboratively with the sponsoring employer? Great question.
Yes, I agree. It's a very good question. And the answer is there's no playbook to this. There's no standard rule on how to do it. You could do either. If you wanted my recommendation, I would say go and get one on your own initially and see what it says and see what you think about it, because it's always possible to share it with the employer and you'd share it with them on a limited waiver of privilege basis. You can set it up in that way so it's shared with them, but then it's not disclosable to members. But the problem is, if you go and get a counsel's opinion that you don't really like and you're doing it with the employer and the employer is effectively your counterparty that you're going to have to negotiate with, I think it's much better to sort of know in private what counsel has to say before deciding whether or not you want to unveil it to the sponsoring employer.
Brilliant. Well, I think it's fair to say I'm actually personally very happy to have both Aaron and Charlotte at my fingertips to help with trustee clients, to try and avoid a lot of the things that we've been talking about today, to come to a pragmatic solution to any problems before we have to worry about going to court and racking up costs for clients. So I want to see whether today's session we've done our job and allayed your fears in respect of using the likes of Aaron and Charlotte. Aaron's going to put up a final question for you. How do you feel about working with our lovely pensions dispute specialist? Great. Who doesn't like it? Rather spend time at the dentist. Yeah. Mixed feelings, but I would be more confident they will find a solution.
Yeah.
Let's see what you think. How good a job have we done?
What a tactful bunch you are.
Well, that's certainly better than where we started, Aaron and Charlotte. So well done. It's yes. So people won't avoid you, but mixed feelings, I think you'll take that 58% mixed feelings.
Absolutely, yes.
No one would rather go to the dentist. So I think that is good work, all well done. So that brings us to the end of today's session. I hope you've enjoyed it. We would much appreciate it if you could fill out the feedback form that you'll be provided with at the end of the session. It just helps us to get ideas for future topics that you might find interesting. And it just remains me to say thank you so much to Aaron and Charlotte, and thank you for joining, and have a good afternoon.